प्रवीण भाई सबको नमस्कार.
Namaste, namaste.
Now completed. Please start.
Now it is okay. Chowda sir.
Yes,
recording
sir.
is on now.
Yes.
Parveen bhai.
Okay. Yes.
Hello.
Mukhtar bhai.
Subol Chandra Sardar from High Court of Calcutta.
Yeah.
He is also joining with us.
No problem. Subol.
Subol Chandra Shah.
Okay, you ask him to write his name.
Subol Chandra Sardar.
Okay.
Okay.
Yeah. Ask
Okay.
them to join quickly. We are going to start now.
Okay. He is already going in now. Okay.
Yeah.
Justice Chandru, just tilt your screen a little away from you because your head is slightly not visible. Yeah, this is much better.
This is okay.
Now it's okay.
Better, sir.
This is perfect.
Good evening, sir. I am a new participant in this program.
Hidayat bhai. Hidayat bhai.
Yes, sir. Yes, sir.
પ્રવીણભાઈ શું કહેતા હતા? હિદાયતભાઈ હાજર છે?
હું હાજર છું પ્રવીણભાઈ, અને બધા મેં અનમ્યુટ કર્યા હતા. મેન્યુઅલ એટલે શું અવાજ કોઈનો ડિસ્ટર્બ ના થાય. હવે અનમ્યુટ કરીને કહો આપ જેને જે કહેવું હોય. प्रवीण सर अनम्यूट करो आप.
I think we should start now. Where is Hansaben? Narendra bhai? Narendra bhai? Narendra bhai, what is this?
नरेंद्र सर अनम्यूट कीजिए आप.
We are looking for Hansaben to introduce and well.
हाँ बोलो.
Narendra bhai. Narendra bhai.
हाँ बोलो.
क्या છે Hansaben? I think we should start now. नरेंद्र भाई हमें चालू करिए.
एक मैसेज મોકલાવ્યો તો ફોરવર્ડ કરો કે પાલગર કોને ફોરવર્ડ કરવાનો? કાઈ કર્યું ક્લિયર કન્ઝ્યુમર તમારો
Anyway.
એની બધી સાઇટ પર આટલું સરળ રહેશે કે તમારો કનેક્શન કટ કરી દેવામાં આવશે. અરે
Anyway, now we will start. We will not wait for anybody now. Yes. Let us start this program now. I welcome on behalf of Forum for Fast Justice and National Federation of Societies for Fast Justice to all of you, specifically our guest, Sri Justice K. Chandru sir, Sri Sailesh Gandhi ji, Sri Dr. Raj Kachru ji, and we yet wait Mr. Bhagwanji Rayani to join. In the meantime, I request some of our activist member maybe Narendra Bhai to talk to Bhagwanji Bhai and ask him to join immediately. Narendra Bhai. Now, to introduce Justice Chandru sir, since the Hansaben is not yet available, I don't see her on the screen here. I will do the job myself. Justice K. Chandru is a retired judge of the Madras High Court. His name is a household name in Tamil Nadu and is very famous, more as a leader rather than a judge, former judge. He has disposed of 96,000 cases during his tenure as a judge. As a leader of the Students' Federation of India, he had examined the witnesses before a judicial commission appointed to inquire into the police atrocities. And at that time, the atrocities, why the thing was, again, the chief minister and all, that the protest, it was a strong protest, and he was representing the students' union, specifically SFI. He is also known for a case in which that took place in 1993 when he was practicing as a lawyer, based on which the film Jai Bhim is dedicated. His biography, I Too Became a Judge, that is released in Tamil very recently in a compendium of numerous hair-raising adventures. Justice Chandru, also a fierce critic of the judiciary, was able to rise from the bar to the bench. That is what he has stated in autobiography, with number of incidents telling names of the politicians and the people in judiciary. That is, the daring which he has is unparalleled. There is a lot more about Justice Chandruji we can say here, but the list is long. Entire 2 hours can be less for that. So we welcome Justice Chandruji to this webinar with full of our heart, and we look forward to your valued addresses. Sri Shailesh Gandhi is another speaker. He is an ex-IITian, former Central Information Commissioner, Government of India, and a strong supporter of right to information movement. He is associated with few more social organizations and is also with the global associations of IITians. Other speaker is Sri Bhagwanji Rayani. He is the founder chairman of Forum for Fast Justice, based at Mumbai. He is a strong Gandhian and a champion of fast justice movement throughout the country. He is also an author, thinker, and crusader for public causes, for which he has already filed more than 100 PILs in High Court and Supreme Court of India. And the fourth speaker is Dr. Raj Kacharu. He is the technocrat, president of our National Federation of Societies for Fast Justice, New Delhi. The federation primarily works on access to justice, for which they work operating helpline 181 for women and 15100 in partnership with NALSA in Chhattisgarh and Jammu and Kashmir. Federation has also filed PIL in the Supreme Court of India demanding continuation of virtual courts, in which High Court of Gujarat, Uttarakhand and Madhya Pradesh are the respondents. Another gentleman is Advocate Dr. D.K. Chawda. He will be conducting the discussion part of this webinar. He is a consultant trainer for corporate, government bodies, college, universities, NGOs. He is also a paper setter, examiner, and external resource person for colleges and universities. He is one of the strongest pillars in promoting our Society for Fast Justice Ahmedabad chapter. He will conduct the discussion session in place of Dr. Raj Kacharu, since Dr. Raj Kacharu has been taken as a speaker in place of Mr. Jagdeep Chokarji, who has his personal problem with the family, where someone is very, very sick, particularly his sister. I welcome once again all the guest speakers as well as the participants. And I begin with requesting Justice Chandruji to give your inaugural address, sir. Justice Chandru, sir.
Good evening to all of you. I'm happy at least a section of the people were willing to ask me the question as to how I was able to manage my court and to have a substantial disposal of matters during my tenure as a judge of the Madras High Court. Fast justice is not an important topic of the day. It's also a constitutional right under 14 and 21 of the Constitution. Now, the question is that the accumulation that has gone, everybody talks about that. There's a 41 million cases pending all over India, 72,000 in Supreme Court. In our High Court, Madras High Court, it is 7.1 million, 7.1 lakh cases. Now, the question will be, whatever the pendency, whether people who come to court will get justice on time. It is just not a request of the poor. Even the corporate houses, even the management, even the institutions do expect that kind of a thing. Now, recently there was a death of a corporate giant in Tamil Nadu, Mr. Shankar of the biggest industrial group. Once in his social media, he said, "We need more Chandru." Does it mean the quantity of pendency could be resolved by few fast disposal judges? That's one issue. Does the proportionate increase of the judges will automatically bring down the pendency? One another issue. Now, the persons who should be more concerned about this is the judiciary itself. But to my disappointment, there is hardly any move on the part of the judiciary to see to it that people get justice faster, quicker, and quality justice. The recently Chief Justice of India said in the Supreme Court that people expect instant noodles, instant coffees. I do not think you could minimize the desire of the people to see certain end to their litigation. That is their constitutional right, and it is the obligation of the judiciary to provide such disposal. Recently, there was a seminar in Hindu where the two chief Supreme Court judges and few chief justices of the various high court participated, organized by the Bar Council of India. So a friend of mine from Hindu called me and said, "Why you are not there in this seminar?" So that's a question now. There are people who have something to say. There are people wider. There are bureaucrats. There are retired officers of the government. There are people who are concerned with judiciary. There are people who worked in the judiciary at different levels. I do not think there is any serious attempt to gather the resources, gather the inputs from them so that a workable solution can be found. Now, this is one thing that while there is a problem, everybody knew it is there. How to resolve the problem? Second is, you cannot find some artificial answers to this problem. In fact, after the movie Jai Bhim came, so in the end of the film, there is a end card which is put at where they show that I have disposed of 96,000 cases. Even Mr. Shailesh Gandhi tried to contact me and said, "How is it possible?" Then I said, there is some study has been done by some university students in Delhi. I'll send you some monograph of that paper. I have sent that paper. I only very surprised that why only people outside the judiciary are interested, and what about the judiciary itself? What about the lawyers themselves? What about the bar council? What about the various bar associations? And what today now you find, I can tell you a small example. Now for the last 2 years, there was virtually only online hearing and trying to manage the show, and many times there were forced closure of the court and the online, how much it helps the litigant. It only showed that the judiciary is still alive and doing some work. But the larger problem of qualitative disposal and satisfaction of all branches of the judiciary, that was lacking. And secondly, there's also a lot of dissatisfaction among the young lawyers that they do not get enough attention during the online program. Offline, what happens is a different issue, but then online, that's a real grievance. There is hardly any study that how much work was done, how much qualitative disposal was done during this period. There hardly anybody speaks on that. But everybody claims that the university, the court has done some good work during that period. Give them whatever the benefit. Today, now we are offline. But the loss that we have suffered in the 2 years, among the judges, there was a discussion whether we should abolish the summer vacation, which they customarily have. There is one sensitive issue. Should they have a summer vacation by which substantial portion of the mandates are lost? This is one issue. But some conscientious judges said that having regard to the last 2 years of pandemic disruption of work, we will skip the summer vacation. There was a huge opposition to this kind of proposal. And now everybody is enjoying. Many high courts have already gone on vacation. Shortly, we will find Supreme Court also going through the same thing. Now, if you see, one major issue is the accountability of the judiciary and how much work or how much output that the judges individually and collectively put. Now, this issue, when you start, first question is the working of the judicial system. Now, in fact, I once wrote in a paper that our judges work in between 2 holidays, 1 working day they work, which means some 180 working days. Even within that 180 working days, the total hours for each day is around some 5.5 hours. And many a times, many committee meetings, many functions, many other rituals are done within this 5.5 hours. Therefore, ultimately, the number of days they work is 180 days and not 210 days, which they claim, which is not true at all. And thanks to bar eternally going on direct action on many times, eternally calling for stoppage of work or closing courts, this is also reduced. In fact, during my tenure, I saw the statistics for 2-3 years in 2009, 2010, and 2011. The number of days our Tamil Nadu courts lost was nearly 35 days to 40 days, which means even this 180 days was not a complete working year. It's about 140 days. So there is one issue. Should not the judges, while demanding better service condition, constitutional protection for tenure, and several other issues, should they not think they should come forward to put more output? It never happened, especially in a poor country like ours, struggling to come up to the world arena. Should we not show more working hours, manpower to solve the problem? If you talk to our brothers in the judiciary, many times I had occasion to discuss with them, they'll always say 2 things, that this is a historical arrears with which we are not concerned. I was not responsible. You are not responsible. There is a question of getting worked up about this. The second defense is that calculating something as arrear itself is wrong, because total number of matters instituted particular year, total number of items disposed of in the same year, the difference is considered as disposal. But whatever that is pending already is not the concern of the existing judiciary. This is a historical accumulation or a baggage with which we are not concerned. Secondly, among the judges, the type of output that is put, it varies. Humans are not almost equal on every respect, but there is no systematic effort to collectively come forward and take a decision to decide how to solve this problem. This is one. This is, I will only say, not just ignorance, but is the deliberate omission or a deliberate attempt to bypass the issue. This is one thing. Secondly, talking about artificial solutions. Now the people say artificial intelligence, AIQ. People talk about alternative dispute resolution, talking about mediation, conciliation, and finally low cause alert. Now these are all the issues which are now being pressed into. Nobody says no, because from 1976, the CPC, the Civil Procedure Code, contains provision for alternative disposal. But they overemphasize on these issues, where there is an adversarial litigation is a substantial part of litigation. Now you try to propose, you bring in solution, to bring in mediation or low cause alert. How many cases are really being solved in terms of low cause alert? This is another issue which anybody has to see. After the introduction of the Legal Services Authority Act 1987, now there is an increased emphasis on low cause alert. The statistics which they release from time to time are really misleading, because if low cause alert, if the national low cause alert is able to dispose of several lakhs of cases, there need not be any pendency at all. So what happens is the statistics are done in such a way, the window dressing, even a pre-litigation matter they are solved. Take for example, arrears payable to telephone companies. Now there is no notice, there is no case, but then they issue notice on the behalf of the companies and try to get some amount to the company and solve the problem. This is not a matter which has yet to come to court, but yet they would try to claim that this is a statistic that we are having of so many lakhs of cases being disposed of in a single day or in several local. If this is true, there would not have any arrears at all. I said, why should we try to tell people something which is not true or which is not realistic? Now they go to telephone companies, so many other commercial institutions which are there is some. You cannot act like a recovery agent and then say you are solving the problem. This is another. That means you are only trying to go away from the reality. Now, if we have 7 lakh cases, when on earth these cases will be over, and when on earth you will entertain fresh matters so that the court will be relevant to the larger issues. This is one. The third issue is the parliament trying to make new laws and then pass on the burden on the court system without creating enough infrastructure facilities for the judicial apparatus. Now, the classic example is a check negotiable instrument, which they call it. Under the negotiable instrument, if you have a dispute, there was a time when the Civil Procedure Code, under Chapter 37, provided for a summary trial. But the experience showed the summary trial became a longer trial than an ordinary civil suit because the procedure that was involved, a defendant even to file a reply, he has to seek leave. Now the leave is refused, you go to the High Court and then get it solved. Now the experience showed successive years that the check cases did not get finality in civil matters. Then suddenly they thought, why not we shift it to a criminal case? An amendment came to the Negotiable Instruments Act, Section 138 was introduced. Suddenly everything went to a criminal court from civil court. I think wrong because you may provide a new forum, there are enough magistrate court. But what really happened was, in every criminal court, the clogging of the criminal court system with so many check bouncing cases, which is a white collar crime, which really displays the real Indian Penal Code crime, the real crime for which these courts were being intended. The trials have stopped and only the white collar cases are being heard. For every 3 white collar cases, there's one IPC case. And the system of disposal is so easier in a check bouncing case. Most of the magistrate court became a check recovering authority. Now, that also was not very satisfactory because the number of cases filed in the High Court over such orders and so many haggling about getting the money. Now the parliament thinks of why not we have a compulsory Lok Adalat for all this. This is another one issue where every time you keep shifting without knowing what is the burden on the judiciary and how much judiciary is capable of disposal of this new matter, new crop of issues. Now recently, the Rajya there's a discussion on the mediation, compulsory mediation. Now the compulsory mediation is only an exercise that how much you see that this could solve the pre-litigation strategy as a strategy. In all these cases, I find there is no serious discussion on how much this will help to reduce the existing pendency. There is a study done by some few scholars who feel that at least it will take 3-4 generations for this to be over without there being a fresh filing. So therefore, we have reached a stage where that the system has come to a nadir's end, where nobody is able to solve this problem. It is only NGOs like these societies which now talk about on a peripheral way how this problem can be solved. People who are really concerned, do they discuss this? People who are really involved, people who are involved in the system, do they ever discuss this issue? Every part of the judicial apparatus or the judicial administration, they go in a different direction. Now, let me go to a larger question because it is left open for a discussion on the question of appointment system. though it may not be directly involved, but I strongly feel the quality of appointment, the quality of selection process, the need to have a overall of this process and need to study from our past practice. Is there any serious study as to how, where the system of selection has failed? Not only subordinate judiciary, I'm now talking about the higher judiciary, both High Court and Supreme Court. Have they ever recruited people who are really helpful or to solve the problem which is already there? I think there's a fundamental mistake that in this country that we have a system where judges themselves select their own judges. And as rightly pointed out by Justice Ruma Pal in a seminar, one of the most secretive process in this world, and it looks like a old boys school association where two boys can bring in the third boy to the association. Now this, everybody says no independence of judiciary. All right. Now with this system which is in fold for the last three decades, how much independence of judiciary has been protected? One question. Now we see every media, every newspaper, every breaking news, some judges saying this or that. Nothing is from their orders, nothing is from their judgments. It's all off the cuff remark made in some seminar, made in some meetings, made in the open court, some off the cuff remark. There is no serious discussion on this issue. And most of the time, this issue is stonewalled or the fears defense that independence of judiciary. How much independence of judiciary is being protected by this system, I am unable to understand. And if you think the constitutional amendment and the act which has brought in for national appointment of judicial commission is flawed, they could have think of amending that and bringing a more foolproof system which is acceptable, which can pass the muster, but that is not then done. The reason being, the present system is easy to pack people of their own choice, people of a particular dispensation, people of a particular political orientation. Now, this is something which is most dangerous than any other issue that we are going to discuss, because if you are not going to have a qualitative judiciary, then the result will be a different result. I think with these few introductory remarks, I think other speakers can speak and we can have a question and answer. I think these are the issues which I consider more important to look into, and the introspection, why this has happened. Do we have a system by which we are going to have a post-mortem, a study of a past? That is one issue. Because most of the people think it is not their problem. Therefore, at least societies like this has come forward to have a wider discussion. Mr. Shailesh Gandhi, I am very surprised, senior officer of the government, more concerned on this issue, especially dealt with the Information Commission. Now, if he could think that this is a most important issue, I think everybody should also think. He asked me, have any Supreme Court judge, has any High Court chief judge ever asked you, how are you able to solve this problem? How are you able to dispose of this problem? Of course, a small section of the judiciary still concerned, who are very sensitive on this issue, they did ask privately. But there is no systematic work. In fact, today, the information revolution is so much. Every judge their disposal, every single judge disposal is collected and sent to the NICMET, and it is available in All India database. Therefore, sitting in Delhi, in one touch of a button, you know the quality of judges all over. Now, this is something where the higher judiciary, the judiciary which is responsible for distribution of the resources, appointment system, they could still think that where the mistake has gone. I could even say without fear of contradiction, there are judges in this higher judiciary who have not done even a single small, they have not even put a small twig outside, and they have not disposed of even a single matter. How is that such people are able to get in and into the judiciary and enjoy all the perks, all the salary, all the status, all the protocol arrangement, but not any disposal? Then why, who is responsible for the system? Who is responsible for such a recruitment? Has anybody taken to task for these things? Therefore, the fundamental question I feel is the accountability of the judiciary to explain to the people where they failed and what they propose to do to solve one of the major problems of the justice administration system in this country. Thank you all.
Thank you very much, Justice Chandru sir. You have opened a Pandora's box. Justice selecting justice, there is a problem. Judges not delivering a single judgment, but still they are enjoying the salaries and perks. I will just, before inviting Sailesh Gandhiji, I will just give an example. Supreme Court, a petition was, public interest litigation was dismissed, rather it was not dismissed, it was, the judgment was not allowed. And the matter was a number of judges from Karnataka, including those who have not even passed the merit, they were selected as judges. And the matter, and they delivered judgments also. Mukhtar bhai, unmute करके बात कीजिए. And the result was, Supreme Court says they have delivered the judgments. They have done all these things. 5 years they were in the chair. Now what to do? If we dismiss them and all the things, there will be no lot of complication. As such, the petition is, without any order, is dismissed. This is an example of gross unaccountability on the part of senior judges in the Supreme Court. But if we speak anything, contempt of court. That is another big problem. So thank you very much once again, sir. We will listen to your more valuable comments and this during the discussion part. Sailesh Gandhiji, we warmly welcome you to express your views, and particularly Lok Adalat, about arbitration and mediation, what Justice Chandruji has said. Our experience is also that they are all simply showcases and nothing more than that. Sailesh Gandhi, sir. Sailesh bhai, unmute.
Namaskar
Yes,
to
sir.
all of you. Following Justice Chandru is a very difficult task to take up. What Justice Chandru has done, Mukhtar ji, aap please mute kijiye. What Justice Chandru has done is, in a 7-year span as High Court judge, he has disposed an average of 14,000 cases a year. The national average for disposal of High Court judges, and we've done a deep study on this, is 2,000. Mukhtar ji, aap please mute kijiye. Will somebody mute Mr. Mukhtar? The national average of disposal for High Court judges is about 2,500 to 700 cases per year. Justice Chandru has disposed 14,000 cases a year, and I would still plead with him. Mukhtar ji, please mute kijiye. Praveen bhai, sorry about that, but I think this was constant background.
मुख्तार भाई, इधर आप बंद कीजिए या हिदायत भाई. What is this? हिदायत भाई, आप हैं कि नहीं है? Sailesh bhai, continue,
Sorry.
please.
So sorry about this. The point is, people, we've been looking at it from an average judge disposal concept. What Justice Chandru has done, I wish everyone could do half of that. There would be no backlogs. We could do it half the number of judges we have. Justice CDI Thakur, with Mr. Modi on stage, had tears rolling down his eyes and saying that we need 70,000 judges. Whereas the sanction strength right now is about 24,000. When Justice Thakur had this performance, it was about 23,000. Now it's about 24,000 judges totally across the nation. What we found is that from 2006 to 2019, and data is taken from the Supreme Court's website, the average backlog increase is not very high. This is a fiction. The average backlog increase is about 5 lakh cases a year, whereas the average disposal is around 1.5 crores to 2 crores a year of the total judicial system of India. So 5 lakhs is not a big figure. This translates into roughly 5% of the matters being left behind. And what we also discovered is that the vacancies in the judicial system are over 20% average. There is no year in which there's no vacancy. In fact, and just to explain how lightly this whole issue is taken of appointment of judges, of filling vacancies, the Supreme Court had 2 retirees this year already. But the names were proposed after they retired. And the Chief Justice says government doesn't sanction positions immediately. I think it's common sense that you must submit the names at least 3 to 4 months before retirements. 7 more judges are due to retire in the Supreme Court this year, and the names have not been suggested. This problem of vacancies has been taken and pendencies has been taken very lightly. In many countries in the world, 90% of the cases or more are disposed of in less than 1 year in a court. Over 90%. In India, in 1 year, only 25% of the cases get disposed right now. And over 3 years, about 45% are pending. The courts have become a torture chamber for the average poor common man. For the rich, it is okay. By and large, they are able to get their justice in time. They are able to hire lawyers who can delay matters or expedite matters as they desire. The simple elementary principle of first in, first out. If I go and ask an old 80-year-old lady in a village, supposing there is a queue who should be served first, she will tell me the first person should be served first. Now, I'm not saying a complete queue can be maintained, but some semblance of a queue should be maintained, which is not being happening in the judicial system in the name of independence of judiciary. This is a major problem. My submission, therefore, is, whereas it would be fantastic if we had 1,000 judges as replicas of Mr. Chandru. And I'm again pleading with him and saying, sir, please write out how you achieved this, because then it can be held. The other judges can be told, why can't they do something like this? They may do half of yours. They may do 1/3 of yours. Even that would be a huge change for the whole system. Besides this, I would like to point out that in the 14 years period, 2006 to 2019, the increase of pendency was only 68 lakh cases, which is about 5% per year. In the 2-year period, 2020 to 21, the increase is 62 lakhs in 2 years' time. Previously, it was 68 lakhs. I'm very sorry to say, with deep pain, I'm saying this. During the pandemic, the judicial system just collapsed. I have heard of lots of places where the courts were just locked up for months, not for a few days. Other places, the judges would work for 1 day or 2 days in a week. That is why it collapsed completely. Despite a pandemic, in a 20-year period, we find the national increase of 8% per year for the whole period and over 20% vacancies. If vacancies had been filled up, it's a no-brainer that each year the backlog would have gone down. And that is extremely important. Not having to wait for a judicial system is very important. People say hurried justice is buried justice. They bury people in the meantime. People lose their lives, their lifetimes go in courts, in literal torture chambers. And the maximum suffering is on the poor and the disadvantaged. Nobody can deny. You can have a legal aid system, you can do what you want. So long as you have a long queue which is indeterminate. So long as you follow a FIFO system, you are asking for trouble. What we have today is a Matsya Nyaya. Incidentally, our finding is backed by 2 other sources. One is the 245th report of the Law Commission of India, in which also they have taken rate of disposal per judge as a benchmark. And our own finding is that the rate of disposal per year in the subordinate judiciary varies by just 6%, the average variation over a 12-year period. In the high courts, the variation is 8%, which means it's a reasonable forecast that if you employ more judges, you will be able to deliver and they will probably dispose at around the same rate. Around, I'm saying. If we take Justice Chandru's thing, even now we've got a surplus of judges. I also want to point out how frivolously, I'm using the word frivolous, the whole issue of numbers, statistics, and number crunching is done in the judicial system. Recently, the Chief Justice of India made a statement which was reported everywhere and media men gave with it. They said over 50% cases are government cases. As if the government did something, they can drop it to less than 50%. And therefore, there was a great furor everywhere saying government is responsible for the disposal. A simple statistic I would like to place before all of you. 90% of the total cases pending are in the subordinate judiciary of India. In the subordinate judiciary, 70% of the cases are criminal cases, in which the government is one side. 70% of 90% means 63% of the total number of cases is criminal cases in the subordinate judiciary, where government will have to be on one side. And there will be other cases apart from that. There will be criminal cases in the High Court. There will be also civil criminal cases of other natures and so on, where the government will have to be involved. Apart from that, there will be others. Please look at numbers. The problem has been, as Justice Chandru said, judges appoint judges. That's problematic. But even if you forget that, I'm saying appoint anybody, appoint a donkey there, he will still dispose something. Nobody can give completely. There will be some rare instances of judges who are very bad. By and large, most judges are average judges who will respond like the others and dispose of like the others. But the problem I find is nobody takes ownership of this. Who's responsible? The standard story in civil society is government is responsible. Government को कुछ करना चाहिए. Government नहीं करेगा तो कुछ नहीं होगा. Prime Minister is responsible. Let us take a factual small check. High Court and Supreme Court judges cannot be appointed until the Supreme Court Collegium recommends names. Cannot be appointed the way the system works right now. And in most cases, the recommendations are made months after retirements. In one case, I noticed that the recommendation for names was made by the Supreme Court Collegium 18 months after the retirement, the vacancies that occurred in a High Court. Nobody takes ownership. For the subordinate judiciary, from what I understand, it's a joint venture between the state government and the judicial system and the High Court judicial system. There also, I've come across cases where, and this is a competitive exam, 100% of the candidates are failed and people gloat over it. What kind of nation am I running? In my opinion, the Chief Justice of the High Court should take ownership of ensuring that vacancies are not left in the subordinate judiciary, and the Supreme Court Chief Justice of India should take responsibility and accountable. He should say, I'm accountable. I find it very difficult to understand. The Supreme Court issues orders to the government saying, fill up all vacancies in the Central Information Commission, fill up all vacancies in the tribunals. But they don't look at themselves and say, are we doing our job? Is the government doing its job of ensuring that recommendations are made before time? Similarly, for the subordinate judiciary, I believe if the High Courts take a responsibility and are held accountable, the Chief Justice of High Courts, if they crack the whip, very few governments will not agree to see that the vacancies are filled up. It's a joint responsibility. For God, I've heard two arguments from many judges that I know, retired judges. They say, one, we cannot find good judges in India. So I told one of them, I said, let's lock up India and throw the key away. India mein अच्छे judges nahi milte hain, let's import judges from Tanzania, Zambia, Somalia. Because countries, from the more advanced countries, nobody will come to India as a judge. In the same breath, within 10 minutes, they say, we need 3 times the number of judges. Can we see the illogic of this whole story? And people are basking and saying the Supreme Court in 2002 said we need 50 judges per million population. Where is the arithmetic? I dare say we are talking of judicial disposals without any arithmetic. The Niti Aayog came up with an absurd statement saying India will need 324 years to clear the backlog. No arithmetic, nothing done. Justice Chandru also mentioned, people said, even if you don't, please do the arithmetic. If we have no fresh cases, all the cases will be disposed of in 2 to 3 years' time. 4 years maximum after the pandemic. Without the pandemic, 2 to 3 years was the normal period. In case we had no further cases, which is impossible, but that's not the point. The point is, if we can change everything, wonderful. If we can change the vacations, great. If we can make the judges more efficient, fantastic. If we can get judges to take tuitions from Justice Chandru, fabulous. But even without that, let's at least focus on vacancies and stop this nonsense of having a Matsya Nyaya, where the big fish eat the small fish. The poor get eaten away. They keep suffering because of poor justice systems, lack of justice at all. The other thing which may help to some extent is technology. It's very simple things. E-filing has been supposedly accepted. The Supreme Court Chief E-Committee has been around since 2005. They've said e-filing. If e-filing was done, 3 lakh trees each year would be saved, millions of liters of water would be saved, and crores of rupees spent on paper would be saved. Case listing should be done by a computer program by submission is where 70% should depend on first in, first out, 25% urgency set criteria, based on set criteria, and 5% only should be the override given to the judges. Adjournment number of times and time for adjournments should be decided by a computerized program based on set criteria. And I would invite people to Justice Chandru, of course, I'm hoping, I repeat, will show us a way of how he is able to and how all judges can dispose maybe 5,000 to 6,000 cases a year. But I was also very impressed with a small video clip I saw of Justice Kazim Ali Malik in Pakistan, who also has done phenomenal work in terms of disposal. Disposal of cases is important. I wish all judgments could be fair and reasonable and to the best of everyone's ability. That may not happen so long as I have human beings doing this. We are talking of artificial intelligence. We are not even doing the basics. And just one last thing before I end. What a farce the court system is made of e-filing. Many high courts, I'm aware, they say you must file your petition by e-filing. Fair enough. But nothing moves until a hard copy is submitted. Okay. On hard copy, changes are made, corrections are made. And then the hard copy is scanned. And nobody uses the scanned output, either of the e-filing or this. What is used is the paper. If we look at our judicial system a little carefully, yes, efficiencies can increase, people can do much better, etc. I concede. But even if we can't do that, let's at least fill up 20% vacancies. India will be a much better country. The judicial system will actually deliver to the poor, to the citizens of this nation, and become a justice system. I repeat, over 90% cases must get disposed in less than 1 year, and above 3 years, in my opinion, it should be less than 1%. And a lot of countries have this record. There's nothing outstanding. There are some cases that drag on, but there are very few. This is the norm, that cases keep dragging, and we look at it and say, this is a way we do justice. Thank you very much.
बहुत बहुत धन्यवाद शैलेश गांधी साहब. अपने नीति आयोग की बात की, मैं उसी पे जरा सा कमेंट करके राज कचरू साहब को बुलाऊंगा. नीति आयोग said in its statement, maybe it was 2016-17, something like that. In a strategy paper, they says at that time the pendency was 28.4 million, 2 crore 84 lakh. They say it will take 324 years if no new case is filed to dispose of this matter. Now today, 2022, when we are discussing, pendency is almost 4 crore 70 lakh. How many more years will be required if we believe Niti Aayog? You are talking about the quality of judges. Here we have the people in Niti Aayog who also are calculating like this. Anybody can laugh at it. Yeah. अब मैं रिक्वेस्ट करूंगा डॉक्टर राज कचरू साहब को एज द नेक्स्ट स्पीकर 15-20 मिनट में आपको अपनी बात रखनी है.
1 minute. Praveen ji, may I take 1 minute?
After when during discussion,
No.
not now.
No, nothing to speak.
Not now. डॉक्टर राज कचरू सर.
इनको बोलने दीजिए 2 मिनट तो क्या है.
नहीं
अच्छा,
बाद में डिस्कशन में करेंगे, अभी नहीं.
चलिए ठीक है.
मैं डिस्कशन नहीं करनी चाहता, मैं आपसे एक ही रिक्वेस्ट करना चाहता फॉर द डेकोरम. For the decorum.
Decorum is to let the speaker speak.
Means that we want some solutions, not
That
statistics.
we will discuss
Please.
later on, not now.
Okay.
Let the speaker
Tell
complete
us
his
the
speech.
solutions for what we are.
We are going to discuss everything. Please, Raj Kachru sir.
Let me try. पहले तो मैं सबको नमस्कार बोल दूं. Namaste. Okay, I'll speak in English because there are many people I see who don't.
No, Dr. Chandru sir, Justice Chandru sir.
Justice
he
Chandru
doesn't understand Hindi.
certainly would prefer English, and I prefer myself. And it is a privilege to be speaking on the same forum as Justice Chandru. I have heard about him a lot, and I have seen his avatar in the film, and a lot of inspiration can be got from him. So it's a privilege for me, at least, to be speaking on the same forum as him. So now I go to Pramod Bali. Let's talk about solutions. We have been doing it for the last 7 years, diagnose the problem. We can put the problem diagnosis in different compartments and boxes and things. Where is the solution? And what is the solution? My experience is that if we leave the solution either to judiciary or to government, we could be here for really actually another 320 years. Nothing will happen. Because there are two agencies, one is the judiciary and one is the government. And personally, over the years, dealing with judiciary and going to courts every day, particularly high courts and everywhere, I have developed a great respect for judges. Personally, I think they do a great job. When you sit in a court for hours, and they will come and they sit there and they listen to these lawyers who are half cooked, half prepared, God knows what. I was thinking there must be a lot of patient people listening to this crap many times. But having said that, they are judges. Their primary job is to do judgments. Their primary job is not to manage the whole judicial system. For that, there is Ministry of Justice. Ministry of Justice has 3 joint secretaries for 3 different things. Proper big divisions. One deals with case management, e-courts. One deals with judgments, judges, selection of judges, their retirement and so on. And one deals with access to justice. But if you say and look at them and ask them, what do you do? They say, no, we cannot do nothing unless we get the permission from the Supreme Court or E-Committee or something or the other. So then question is E-Committee people, the head of the E-Committee office boss is Justice Chandrachud at the moment. He must have 100 other things to do rather than just spend all his time. I'm pretty sure if he spends a week or 10 days or 20 days looking at the E-Committee, he will come up with brilliant solutions, but he doesn't have time. He's after all a judge and he has got huge many things. Well, what is the government doing? I have a problem with the bureaucrats. They are doing absolutely nothing. And what they're doing is they're doing a lot of damage. I'll give you just an example. They're doing a lot of damage by lying to the judges that everything is hunky-dory. I'll give you one example. Only last week, I was in the Supreme Court for a petition which is to do with PWDVA, and then we were talking about protection officers and things like that. And Justice UU Lalit gave me a 20-minute lecture on how Nyay Bandhu scheme of government of India is going to resolve all this problem. You just wait for 2 months and this will be all resolved. Question is, of course, he has been misled, but the question is who told him? He's chief of NALSA. The bureaucrats in the Ministry of Justice and the Nalsa must have told him that we are doing a fantastic job, and he believed them. And I don't see a reason why he shouldn't believe them, because there's no other source of information for him. His only source of information is coming from his own people. And they tell him, I looked at Nyay Bandhu scheme. I actually knew this Nyay Bandhu scheme. 5 years it is in operation. This is Government of India's pride scheme for access to justice. It's been in operation for last 5 years. 400 lawyers are employed, are registered to this. 1,600 cases have been allotted. Nobody knows whether these 1,600 people, poor people, actually got any justice or they were looted or what. Nobody knows, no record of that. But at least we said 1,600 people have been allotted. I was asking, my lawyer was with me. I told him, don't say anything. We don't want to get adverse order on this. But personally, I thought a small group like mine, we did 25,000 cases in the last 5 years. 25,000 compared to Nyay Bandhu, 1,600. Question is that we could be talking outside the judiciary and outside the government. But the government and the judiciary, jo khichdi bana rahe hain, whatever they are cooking in the pot, we are separate and they are separate and they're not listening to you. I go back to Justice Chandru's lecture. In the lecture, he said there was a conference and one friend called him and I said, why are you not there? And that's precisely the problem. The people who have something to say, people who spend time on this, people likes of us and who spend time and we spend energy, we look at this day in, day out, and we look at the numbers, we look at the things, we are outside. When you look at, there is Niti Aayog and there is Ministry of Justice and there is this E-Committee. Between the three of these, they cook fantastic plans. You should only read those reports to see that none of these people have a slightest idea of what is the reality. But they just print beautiful reports and it continues and goes on and on and on. Now, to answer Prabodh Bali's question, we need to get involved, enter into these forums. So far, we have resisted. We said we have sent letters when we have said, please accept us, please listen to us. I think we need to force our way into these forums and make a little bit of noise through the judiciary itself. That means more and more PILs talking more and more openly, directly, criticizing these schemes, criticizing these plans, criticizing these situations with data and with proposals, because it is not rocket science. I know it's difficult because judges want control and they should get control. You cannot deny them. They are, after all, it is their court. They want to deal the way they want to deal. It is their intuition, their mind. So many things happen on a court case. Computer cannot run it, but computer can help them manage it. And there are so many possibilities, like the management system that Justice Chandru has created in his mind, or he operated. It is, after all, a management system. He knows, nobody else knows, but it is a management system. And it is practical management system that works within the constraints of IPC, CRPC, the procedures of law and procedures of the Supreme Court. So this is a working management system. All if we can do is to convert this management system and put it in a computer program and tell the government, look, this is your management system and it has already gone through the test of trial. Or if you want, we can redo this. We can put it in a pilot project somewhere else with some willing judge, and let's run it for 2 years and see whether it will work. I can see it I can even think there must be certain things which Justice Chandru has put his foot down on. He said, I'm not going to budge on these things. You could be a senior lawyer, you could be any lawyer, but I'm not going to accept unless this is the way it is going to happen, and that's a strict system. So many of these judges may not be willing to, but if many of them are willing, we should put it this. The question and the point I'm getting towards is that as a civil society, as a society as long as we sit outside and do seminars and talk about between ourselves, nothing is going to happen. We need to enter that room where the decisions are being taken. And if we cannot enter that room, if we're not invited into that room, we need to force our way into that room. If we're not ready to force our way into that room, we cannot do nothing. We could be talking until cows come home about all these things, and we have been talking. My suggestion is we should set up a small research team. I don't know Bhagwanji whether he's here today or not. We should talk. We need to contribute. We need to put up a little research team, and we need to put up data and create the same, create reports and submit it to government from time to time. We have enough work done on access to justice, enough that nobody in India can beat us in terms of access to justice. Whether it is 151, whether it is 181, women's, all sorts. As I told you, we have done 25,000 cases in the last 5 years for poor women and children. So government of India can say that they are doing, they cannot beat big schemes of government of India have not done that many. So we have now sufficient material which we need to organize, put it on reports, form PILs throughout India, go into different high courts, not necessarily Supreme Court, go into different high courts on local issues there and see what happens. 4 or 5 years. Otherwise, we need to create a 4 or 5 year plan. I would think this is the only way that is going to happen. But I have one thing which Saileshji picked up about the Chief Justice is saying about 50% of our state is a litigant and so on, and 50% maybe not 40, but it is well known that the high courts are clogged with 2 types of cases. We have done analysis. It's either civil writ or it is at the lower courts is 138. 138 has become a problem throughout India, particularly in bigger cities. In Delhi, few years ago, when I analyzed the data of Delhi courts, it was something like 60% of the criminal, between the criminal cases were 138. And government of India is doing nothing about it except because it works. I told that time a secretary I said, you have converted government of India into a debt collection agency for rich people. Our police has become a debt collection agency for banks. That is what 138 is all about. So we're not going into the detail, but about the writ petition. My experience, I'm sure Justice Chandru must have seen it for years, is law officers come into court, writ petitions. Some clerk somewhere in the office of somewhere has done some mischief, and you go into court. You have no other remedy. You have only administrators are blocked. You have no choice than to the court. You go into the court and the law officers defend this public servant vehemently without even knowing what's the story. My question, we must ask this and very seriously put in the Supreme Court a petition. Can you define the role of a law officer and the Advocate General? I have been researching it. There is no defined role. Should an Advocate General and law officers of the state defend a public servant, or should they defend the public interest?
Please conclude, sir.
They are meant to defend public interest, not to defend public servants. But it is the opposite that happens. Smallest things that happen, and this is what the Chief Justice also said, that we cannot run the administration. The administration must do its own job. And huge number of cases in the writ petitions, civil writ petitions, all over the high courts are because of this problem. There must be a mechanism, like in the Supreme Court, you cannot go to the court unless the Advocate General says, yes, we should take this matter. There must be a pre-screening mechanism at the administrative level or at the Advocate General's level. We can do this kind of a thing, put in a PIL, and you will see enormous amount of difference, and it will make administration more accountable. Small things I have about 10, 20 things like this, which we can do in forms of PILs. So we must take a decision. Should we stick with the conferences and have these kind of discussions from time to time, or actually go after the government and the judiciary in the judiciary itself by lodging several PILs from from states, high courts? Thank you very much.
Thank you, Dr. Raj Kachru sir. आपने तो कई एक्सपीरियंसेस भी आपने बताए हैं, मगर नालसा के साथ जो एक्सपीरियंस है, मैं हिंदी में बोल रहा हूँ क्योंकि काफी हमारे फ्रेंड्स बिहार से और यूपी से दूसरी जगह से भी आए हुए हैं। तो नालसा के साथ काम करके ये 2 साल के अंदर हजारों केस को जो है, यदि उसको जब सल्टाए हैं एक्सेस टू जस्टिस के लिए जम्मू कश्मीर और छत्तीसगढ़ में, तो बाकी के राज्यों में सरकार उसको हमारे जो डाटा है उसके साथ अपने परफॉर्मेंस को कंपेयर करें। लेट देम कंपेयर इट, अपने आप सब समझ में आ जाएगा कि क्या और कैसे करना है।
ये just 1 second, Justice Chandra,
Discussion, sir.
Lok Adalats, I 100% agree. All the data of Nalsa, Lok Adalat or tele law, all fake.
Yes.
All fake. We must contest these data now.
डिस्कशन में सब बात करेंगे सर। लोक अदालत के लिए मैं एक ही चीज कह सकता हूं कि लोक अदालत में न्याय नहीं होता है, न्याय का गला घोटा जाता है। यू आर आस्किंग द बोथ द पिटिशनर, जो भी आए लिटिगेंट्स हैं, उनको बोलते हैं यू मेक ए कॉम्प्रोमाइज, कुछ लेट गो करो, यू लेट गो समथिंग एंड एक्सेप्ट व्हाटएवर द डिसीजन इज टेकन so that you can come out of the court. Anyway, now before we take up discussion, I will just invite Prabodh Bali to say whatever he wanted to say in few minutes. Prabodh Bali ji.
Thank you very much, Mr. Praveen. And I hope that you may not take it in a different taste. I think every speaker should be given equal time. I have felt this thing in almost all the video conferences, that there are certain speakers who are having the soft corner of the person who is organizing. I would say that at least if there are 40 persons over here, everybody would like to say something. Okay. I think only Mr. Raj Kachru gave one solution. His solution is that we need to organize, put before the government, and so we should file the PILs in the high courts. Okay. So this is the suggestion by him. But who stops him? He's already the president of our association, of our organization. Nobody stops him. A PIL is not needed only from an organization. I myself have filed 20 PILs only in an individual capacity.
Yes.
Let me finish it. I'm bit why I'm frustrated that everybody here wants to tell the statistics and putting up this wisdom of the problems that everybody knows, that we are already in a chaos. We are already in such a situation where there's no hope, no light. But where is the light? Where people are here, somebody should give us the beacon light to us, that this is the road, this is the road map from where we should move. So this is, because you say I have got a very precise time, I would tell you. If he says to file PA, please file PA. Nobody will stop you if you want need funds. Okay?
Yeah.
Okay?
Okay, now.
And instead of telling others their way of going to Lahore, better you go to the Lahore. Punjabi ki kahavat hai, Lahore da rasta na dasso, Lahore nu turo. Second point, 138 is said by Mr. Raj Kachru, remedy only for the rich people. Does he has the what you call a statistics? How many
we will discuss this thing. We have taken your point.
No.
We will discuss with you.
Let me speak, sir. Please don't.
You have got very limited time.
Don't put rope on my neck. Let me speak, sir. Let me speak.
Praveen,
we cannot give you infinite time.
Let him finish.
Government has got no intentions. Government has no intentions only for the poor rich. It is a law anybody can use. If the rich can use the law, because this is India, because in every section, the rich people are having enjoyment.
Baliji, your link is over. Anyway, now we switch over to discussion forum. We will hear Dr. D.L. Chawda for a few minutes, 3-4 minutes, and then he will take over. And in discussion where Dr. Justice Chandru, Sailesh Gandhiji, and Raj Kachru, they will join him. We have also Mr. Raghavan Raja, an IAS officer from Chennai, and he is the promoter of our societies for fast justice in Tamil Nadu. Later, we will talk to him also. So I request now Dr. D.L. Chawda to please take over.
Thank you, sir. Can you hear me? Am I audible?
Yes, sir. Yes, sir.
Yes, sir. So most of the points has been covered. But just to start with, Honorable Justice Chandru, respected Jagdish Shokar sir, who is absent today, former CSC Shailesh Gandhi sir, Bhagwanji Bhai, who is also, I think, absent today, Karya sir, Praveen Bhai, and rest of the other guys who are really concerned about the pendency of cases, fast justice, and judicial independence. I feel obliged today, and it's my privilege to speak in front of all of you guys, dignitaries, and to speak after this kind of big, heads of our nation. It's really very tough job for me even to present something. What I want to present, friends, is right now we are living in the era of Singham justice versus Chingam justice. Singham justice means what? What kind of justice that we want actually? We want a very powerful justice. The justice judicial system which timely gives a judgment, fundamental and other rights are protected of the civilians, protects the constitution, controls the executives under its constitutional limitations, limits the legislature, and much of the other things like rules of law is getting established. But we are not getting this. That's the main concern of all the people present over here, right? We are living in the kind of society, friends, whereby the delivery of pizza is ensured within a span of 30 minutes. But delivery of justice perhaps is not being delivered maybe even for 30 years, right? So friends, that's the main concern. Now let's directly jump to the solution. What could be the solution for the same? Setting accountability of the executives. Most of the time, the executives really, involves or files kind of cases whereby the person is not really involved into the matter, but directly he's involved into that particular matter. And because of which accountability is not set, and due to which, friends, the case gets generated. So at entry level, if accountability of this kind of executives are being set over there, then definitely at entry level, the cases can be curtailed. By filing a PILs, friends, I want to mention one very important, arbitration award, and that is concerned with, that is, just a moment, I think that Australian, yes, that company is White Industries Australia Limited versus Republic of India, friends. Okay, our constitution says equality before law and equal protection of law. Now, friends, in this particular award of 2011, this company came into our country for investment purpose. Most of the time, everybody would be knowing that when the foreign companies are coming into our country, they are coming under some BIT, bilateral investment treaty, and this is always covering some arbitration. In this particular arbitration, which was held in Uncitral in Singapore, it was held that government of India since delayed, means judicial system since delayed for 10 years, pretty long period of 10 years plus somewhat. So the company should be given a compensation, friends. So can't we file a PL? I think one PL was filed in past also, that timely justice is should be a fundamental right kind of, but I think it was not honored. But taking into consideration this kind of awards like White Industries Australia Limited versus the Republic of India, if again something could be done over here, right, filing a PL, then definitely the kind of people like me also can contribute something. Okay, whereby the government was held responsible and the company, that's foreign company, was given the, that compensation kind of things. The biggest and the best solution, friends, what I was discussing with the Sukhdev Bhai also time and again when we were sitting together, that we are into a democratic country, friends. In democracy, always the power comes from the people. Until we make the people aware about all these issues, that these are your rights, you're not getting it, what should be your rights, until that awareness is being developed, we cannot get a solution. Until we have a pressure group generated, that's according to me the biggest solution. And believe me, friends, in IT era, this is quite possible. Now, when the Honorable Chief Justice like Chandru, CIC like Gandhi sir, all these dignitaries are present, friends. And even though we are 30 people in the group, why can't there be even 500 or 1,000 people or 10,000 people in the group? Can you get my point? So until this particular movement becomes a mass movement, friends, nothing can happen. It would be somewhat kind of intellectual discussions. Because until in democracy, what happens? In UP also, in this election, everybody would have noticed that the BJP won over somewhat 100 seats, constituencies, by the margin of 100 to 200 to 500 seats, votes only. Okay. Now, if we make the people aware, we are not concerned about the BJP or Congress, mind well, correct? But if we make the people aware that please generate a pressure group, tell to your political parties that we are not going to vote if we are not going to get a justice in time, because this is very aggravated problem, believe me, everybody is suffering from this. But people are not aware about their rights. And by digital way, what I'm pressurizing all the time, by digital way, by digital marketing, collecting the data, keeping the central database, friends, we can definitely do these things at a minimum cost, at a minimal cost. Rest of the things, the other friends are really, and my senior fellows are really very much, knowledgeous about all the points. But the only thing, solution according to me, which I really want to suggest is connecting the people by digital way, for which I have prepared a couple of plans also, which I'm going to share with the Sukhdev by. Last time also in our meeting, we had shared some of the ideas. Okay, and in future also, we are going to share for the same, right? So connection with the people by digital way, letting them know that this is your right, pressure, generate a pressure to the political parties, party in rule and party in opposition, that yes, we want a justice in time. We don't want a justice after 10 years, 20 years or 30 years, right? When we come to the court, every time we have a limitation act that if it is a civil matter within a span of 3 years, I have to be there inside the court. If it is a consumer court, then within a span of 2 years, I have to be inside the court. But is there any time limitation for getting a justice? Probably no. I see so many cases, friends. In 1981, the case was filed, still it's running in the High Court of Gujarat. And that was concerned with a lottery case, simple lottery case. It's not so complex even. Correct. So pressure group, according to me, by digital way is going to be the best solution. With this, I end up my speech.
Thank you.
Thanks a lot.
Thank you
For giving me this opportunity.
Now, I request again Dr. D.L. Chawda to conduct the discussion where inviting Justice Chandru sir, Suresh Gandhiji, Dr. Raj Kachru, Meenaben Jagtap is also here. You may also join. And Raghavan sir. Please. Chawda sir, you can start.
Yes,
you
sir.
Have 20 minutes.
So in discussion,
25 minutes. 25
yeah,
minutes.
yeah. Discussion, I would first of all invite Kachru sir.
All of them.
Chandru sir and rest of the other participants also. Please suggest some of the key points really which can work out for these things. Because this is going to be a grave concern for the country. I was not doing anything about this kind of society prevailing.
There are questions there's raised hands. They may have questions and then we could answer those questions.
Questions are after this, sir. That is in concluding part. Or you want a question first?
My suggestion is, because we have already said what we have to say. It's only when somebody asks a question, things will get clarified.
Okay.
It's not a point
for question.
Me to repeat
We'll
myself.
give 15 minutes for questions. And
I would, Mr. Patelji, I would like to also present a few.
Question, if you have any question. Paliwal has one question. Paliwal, you can ask your question.
प्रवीण भाई, मैं जस्टिस रमन्ना की स्पीच में सुना था. आप एक चीज देखिए कि अकाउंटेबिलिटी इज मस्ट. जैसे अभी उन्होंने बोला था कि ज्यादातर जितने आते हैं तो ब्यूरोक्रेसी की गड़बड़ी की वजह से या ब्यूरोक्रेसी की कमी की वजह से आते हैं, बिकॉज देयर इज नो अकाउंटेबिलिटी देयर. तहसीलदार की तरफ से जैसे तहसीलदार कई चीजें कर देते हैं तो उसकी वजह से आते हैं. उन्होंने 66% केसेस लिटिगेशन आर ड्यू टू द फेलियर ऑफ द गवर्नमेंट या गवर्नेंस की जो फेलियर है. अभी जो मिस्टर डी.एल. चावड़ा भी जो बोल रहे हैं ना, तो वो चीज जरूर होनी चाहिए कि हम लोगों को कुछ न कुछ प्रयास करने चाहिए कि जस्टिस मिले. सहज सुलभ न्याय की जो अपन बात करते हैं ना, तो जस्टिस हमको वी शुड fearlessly ask for the fairness in justice.
किससे जवाब चाहिए आपको?
चावड़ा जी बोले तो थोड़ा बेटर रहेगा, क्योंकि वो
चावड़ा जी बोलेंगे और शैलेश गांधी जी उसमें सप्लीमेंट करेंगे.
हाँ, शैलेश गांधी भाई भी बोलेंगे, क्योंकि वो आरटीआई जैसे आया तो अकाउंटेबिलिटी एक्ट भी आना चाहिए जैसे आरटीआई का एक्ट आया.
ठीक है, चलिए चावड़ा जी.
Yes, sir. In short, can you repeat, because there was a glitch? I could not hear you. Exact question in one line itself.
In one line, the question is just Paliwal ji. Wait. His question is regarding Ramana's statement that executives are responsible for which pendency comes up in the court. If they do their job, pendency would not have been this one. Because of them, the cases come to the court.
Yeah, that's one of the biggest problem. That's true. But actually, until you held responsible officials also, executives also responsible for something doing wrong for me, with me, until you do that, there is equality before law and equal protection of law. Correct? Article number 14 says somewhat like that. Now, most of the time the government does or functions in what particular ways? The government says केस कर दो, सचिवालय में हर जगह पे आपने देखा होगा कि केस कर दो ना, वो दौड़ता रहेगा. He will continue contesting. Correct. So until you held that official also responsible for doing something, and it should be gross visible. If official has done something gross visible wrong, then he also should be held responsible for the same. अभी क्या होता है पालीवाल जी कि मार के भाग जाओ, खा के सो जाओ, kind of. Correct. For everything, whatever that we are discussing, according to me, we are into a democratic setup. Until the pressure group is generated by the public, until the people raise their voice, that it should not be like this. I want a justice in time. I want this. I want that. Until we can digitally connect with the people, until we have a big mass, our right thing also would not be taken into consideration by the political parties.
Will you add something?
In my opinion, Mr. Chawda is right. I think that my own view is that the solution lies in creating public opinion.
Okay.
Going into courts is not going to change anything, in my opinion. Courts are back on their own thing. And in my opinion, it's not the executive that is so much to blame as the judiciary itself. We are pointing fingers in the wrong place. We नीम के पेड़ से आम नहीं मिलेंगे.
Yes, sir. Chandru sir.
Accept the fact that judiciary has not been taking ownership.
Yeah.
People like Justice Chandru are the exception. But most of them do not take responsibility and ownership of the problem. And I think that's where the problem is.
Chandru sir.
Just
about 50% cases, government is the litigant for non-functioning or improper functioning of the executive. That is the question.
Who is a party is not a very relevant issue, because if you say, as Shailesh Gandhi said, if most of the cases are criminal cases, in which case every side, one side will always be government. This is just to say, sidetrack the issue. There are two issues. Today, you can enforce the fundamental right only against public sector, against the state under Article 12. So therefore, every constitutional petition filed in court, one side has to be a semi-government or a government. Therefore, there is no enforcement of a fundamental right against a private employer. This is one issue. Either a case of reservation or a non-discrimination or a procedure for, most of the cases go to civil side or a semi-labor, so many other factors. Now, in this situation, if you see the number of cases increase, say in the Madras High Court, a substantial increase on the constitutional writ petitions and not civil side. Our civil litigation has shrunk so much, even after the constitution of the commercial division. The number of cases pending are very limited, because by increasing the pecuniary jurisdiction, they pushed off all the cases to lower court. So the High Court is showing a figure that they have very little commercial cases. Now, cases coming from civil court, the lawyer's ingenuity is that most of the civil litigation has transferred into a sort of a quasi-criminal. Now, if you want to evict somebody, you don't go to a civil court. You file a private complaint, you go to the police, enforce them. So necessarily, this also involves the ingenuity of lawyers, also involves a conversion of the cases to civil to criminal, in which case necessarily there is a government side. Therefore, it is not government or non-government. It's a question of competency to deal with the matter, number one. Number two, the judge's ability to withstand pressure and filter matters, and only relevant matters are taken in. Other matters are sent out at the threshold. That fear, that kind of a mental state of mind is not there with most of the judges. They always feel they are obliged to do some good thing to the lawyers. So he wants to get a good name, or he wants to get a good opinion from the bar. And the bar acts like a pressure group. If a judge is very strict, they go to the Chief Justice and lobby for change of it. So the judges who are very strict, judges who try to manage the admission stage, they become unpopular. A judge who refuses adjournment, he becomes unpopular. There are hundreds of petitions, hundreds of representation. So if you are unpopular, you can be a good judge to the people and consumer. If you are popular, the reverse thing takes place, because you tend to admit every case, you tend to order notice every case, you try to oblige the lawyers by giving all kinds of adjournments. And then your own attitude towards work, that you work only like a punch clock, that you just punch machine and go away. That work come at 10:30 and go away at 4:45. The rest of the time, something else is be done. There is no active involvement. I'm not saying that you should work all the time as a judge, but your attitude, that why you have been appointed. You've been appointed because a particular purpose, a particular task is before you. Unless you realize this, and I have seen majority judges, I can say without fear of contradiction, half the time they are not in the court only. They adjourn every matter and go back to the chamber, saying there is no more case. How there can be no more case when you are having 7 lakh cases pending? Therefore, the system of arranging work, the system of disposing matters, the system of planning for the future, and the system of availing all kinds of leave that is available to you. And then the work is the least thing that you can do. The rest of the things are being done very effectively. These are something which there are wider problems other than being who's a party. And even in government, when you say government is a litigant, today increasingly it has become sharing of spoils. A party gets elected, they put their own lawyers into the government panel. Now, result is, you have in Tamil Nadu, for example, there are 200 lawyers for the state government, some 150 lawyers for the central government. Okay. Doing what work? Nobody knows. People who are not trained, and then they're just pushed into the government defense. If any sensitive case where the leader is involved, CM is prestige is involved, they engage some senior lawyers from outside. But in defending the ordinary day-to-day case, there is a total lack of education, lack of training, lack of experience. And this is also another factor. In fact, one court, Kerala court, mentioned that why is this untrained lawyers are thrown into the court and then trying to make the judges do all the work. If there is an inefficient defense counsel, the work of the judge gets doubled. He has to do double the work for that man. This is another one. The third matter which I am very seriously concerned is the trial court, where the Supreme Court very curiously in the All India Judges case said that a boy from law college can become a judge as a civil judge junior division. Now, you know, from +2, they come to law college for 5 years. They have not seen court except in moot court, which is an experiment in laboratory kind of thing. Then straight away they are appointed as civil judge. The logic of the Supreme Court was IAS officers are appointed after writing a UPSC examination and after a 2-year training. And what kind of a training that goes to admission, the start level civil judges? Now we find increasingly problem. The inexperienced starting level judges are also difficult to face the ground reality, face the militancy of the bar, and working in isolated places, they need some kind of a guidance and support, which is lacking from the higher judiciary. The net result is there is some kind of a inefficiency or a immaturity shown at this level. Judges are also experimenting. Now the another point is now said, All India Judges Service. I don't know where they get all this. When half the litigation is a local language, you bring in All India Service, I don't know how it's going to solve the problem. Therefore, sitting in Supreme Court, they dealt with so many matters for which they have no experience, they have no vision, no perspective. And then fancy ideas are being thrown. I know when Supreme Court wrote that judgment for All India Service and also straight away from the college campus.
We'll take another question, sir.
He became a civil judge. Now his experience in the court is zero. He may be tuned to work on the civil side, but he is posted as a magistrate to deal with criminal matters. And there are experienced lawyers standing before that particular judge, and he is unable to face situation. At least earlier there were 3-year bar experience, 7-year for district experience there. That's all gone now. Now, curiously, Supreme Court said they should be given 2-year intensive training. Now, what kind of training? I know in my court, the training is given for 3 months, and the Chief Justice waives the training period and puts them in an independent posting. The result is they are thrown into the wolves without sufficient training and and materials gone into his experience. This is something all the time there is some kind of a training and decision taken by people who have no responsibility at all, except fancy ideas are being thrown. I think this should stop. There must be a intensive study on their experiment. And if the experiment shows or if the study shows that this is not working, they will be able to withdraw that kind of ideas that they've already gone. There are many issues, not one issue.
Sir. We'll take another question, sir.
We need a wider discussion on these issues.
Yeah. Mr. Kanubhai Rathod, sir. Wait a minute. Kanubhai Rathod is there. Kanubhai, unmute करके आप आइए. Kanubhai, you have raised your hand for a question. Yes, Kanubhai. Please. प्रश्न पूछिए, अपना सवाल पूछिए. Don't waste time.
वो वापस म्यूट हो गए.
नहीं, अच्छा. कनु भाई अनम्यूट कर लीजिए ना आप.
सर
अभी आप अनम्यूट है, बताइए.
Sir, my question is that there is provision in CPC section 80 so far as the question of accountability of the administration. During my life as a senior judge, there were so many cases came before me against government. In that all cases, the plaintiff means plaintiff has served notice under section 80 of CPC, despite the fact that all the civil litigants come before the court. They serve notice to the concerned government officer notice, but the officer concerned does not dare to give reply or dare to comply the matter. So there are so many cases comes before the court. So that there must be some provision for accountability of that concerned government officers.
Yes, sir.
Okay.
किससे जवाब मांगते हैं? ना ना सवाल નો જવાબ છે જવા દો. રાઠોડ સાહેબ જવાબ કોની પાસે જોઈએ છે?
જી સાહેબ.
From whom you want answer?
So what will be the responsibility of
your question is raised to whom?
His question is raised to anybody.
To anybody.
प्रवीण जी,
Anybody.
प्रवीण जी इसमें मैं बताऊं 80 CPC में.
अभी रुकिए.
80 CPC में, 80 CPC में.
What is this?
My question.
Yeah. शैलेश भाई आप ही बता दीजिए.
I think Justice Chandru will be the better person for
okay.
this.
Justice Chandru, sir. Yes, sir. We are not able to listen to you, sir. Justice Chandru.
Yes, sir. I'm able to listen.
The question is to you.
Repeat that question.
Yeah, unmuted. Okay.
Repeat that question, please.
Rathod sir.
My question is, sir, my lord, my question is that there is provision of in CPC section 80 with regard to is serving the notice under section 80 before filing a civil suit before the court. But the government officers against whom the proposed relief is sought for by serving that notice, but government officers of various departments does not dare to care to the notice or to curtail the litigation, and ultimately the litigants come before the court by way of filing civil suit, and the matters go for years together. But there must be some accountability on the part of the government officer to properly comply. In the various cases, the reply does not given by the government officers. So what will be the accountability of responsibility of the government officers?
Now the question is very simple. It was enacted at a time when they felt that government should have some notice before a suit is instituted. But then the section itself provides for a waiver of that notice by the court. Therefore, there is no difficulty Under section 80, if you give a notice, if you don't want to give a notice, the court can waive depending on the urgency under 82. Secondly, when notices are sent to individual officer, you do not make the state as a party, you only send notice to the individual. He doesn't know what to do. So now take the Tamil Nadu government. They are now having so many training sessions to a different level of government officers who are in charge of various departments as to how to cope up with litigation, how to prepare defenses, how to come up with a faster defense before the court. What are all the court expect from them? So there is a series of training program for the government officers. I think the trainee officers are also given exposure to the court litigation. If they give like that, this will not be there. Many times they receive notice and put it in a file, thinking that it's only a threat and not an actual suit. If the suit is actually filed, now the Tamil Nadu government is also appointed at district level legal advisors for the collectors and other things. Several departments are having district level advisors. I think these are the issues where the government is concerned, nothing to do with the court as such. It's only a procedure. The procedure can always be waived by the judge himself if they want. But most important thing is not a reply from the government. Most important is all kinds of cases are filed after understanding with certain lower level officers, whether it's a case of encroachment or the case of so many government deals. There are so many mafia, I will use the word mafia inverted commas. The litigations are also hijacked by a group which plans everything from the initial stage to the last stage. These are the racket which the court will have to bust. But on the other hand, court also actively participates in this arrangement that you go file a case and they come and defend, mock defend, and finally some orders are passed, then contempts are filed. So court is also being used for certain other collateral and nefarious purposes. That has to be weeded out by a vigilant judicial officer.
Thank you, sir. Raghavan, sir.
Thank you, sir. Thank you. Thank you very much. Very kind of sir.
Yeah. Mr. Raghavan, sir.
Thank you.
Balaji, you are next.
Yeah, thank you very much. I mean, in the presence of the legal luminaries, I would like to point out one or two things.
Be louder, sir.
Yeah. Am I audible now?
Yes, yes, sir.
Okay. Now, as Justice Chandru had put it, the judges, judiciary, especially at the lower levels, they need training very, very badly. That's one. Now, coming to the main point, I have listed a few points. You see, the reforms in two forms, right? One is internal to the system, one is external. External means say you expect something from the government to do. Okay, government to do. Now you want to increase the number of judges based on certain ratios, right? That will take time. Now the speed of disposal in the courts should take its own time. As some judges have put it will take another 100 or 200 years. Now, in these circumstances, under these circumstances, we as intelligent human beings, or whatever positions you occupy in government, judiciary, or legislature, we need to follow certain practical ways. I would list up one or two before you. Number one, I tell you, I have been being a presiding officer in many revenue courts up to the Board of Revenue. Right now, there are certain ways by which you can curtail, limit the scope of mischief by the lawyers by fixing only that number of cases which can be heard on a particular day. Now, second thing is, I would say, I have been to the Supreme Court. I have seen judges listening for days together on a particular commercial litigation. Now, you please fix certain time limit for final arguments. And also, final arguments should be confined to those very points where the judge wants clarification from the parties. Number two. Now, fourthly, it is a little, of course, it is too much on my part to expect the judiciary kindly fix certain number of cases to be disposed of by each judge, whether it is a civil judge at the lowest level or the judge at the Supreme Court level. Fix certain number of cases. Now, number four, I tell you, many times we keep hearing, there are many cases, criminal cases, where the under trial has already undergone the sentence which was supposed to be given at the end of the trial. Now, my humble request to the entire judiciary, kindly release those people, those who have already undergone the imprisonment, requesting imprisonment. This is, suppose, it is for the state advocate general to put up the case and plead before the courts, and so that all those pending cases where the under trials are numbering lakhs and lakhs, millions under trials, are languishing in the jails. I mean, and eating the money of the government, public money for nothing, and it is leading to inefficiency. Right. Second thing, and I tell you, now looking to the number of years taken by each case, kindly fix certain amount of cases on each working day, hearing day. Old cases pending 20 years ago, 30 years ago, 5 years ago. The judge, every judge should keep certain percentage of cases. Suppose a judge, high court judge, hears 60 cases in a day. Kindly listen to 20 oldest cases. At least give them priority. Thirdly, there are people who are above age 70, 80, they are still waiting for judgment. Kindly fix those cases where the litigants have already gone through 70 years, 75 years. Fix that amount of result to them. Now,
okay, sir.
Now there are
timing short, sir.
And I'll tell you, now there are certain things which I expect from the government side. Okay. Now everybody.
Give us in writing, sir.
I have already sent to you, sir. I have sent you.
Okay, that I have with me.
I sent you.
Yesterday only I have sent.
Yeah.
We'll look at it, sir.
Yeah. Okay, then if you are very short of time.
I already gone through it.
Okay. Thank you then.
Yeah.
You kindly
Now,
circulate it.
Yes, sir.
Thank you very much.
We'll circulate amongst all.
Okay.
Yeah, Mr. Bali. Be precise.
Precisely, sir, there was a question that regarding Section 80 CPC. Already there is a judgment in the Salem Bar Association versus Union of India in 2005, in which the Honorable Supreme Court held that every public authority will appoint a officer, especially to reply for the what you call the notices under Section 80C, and he should be held liable for that if he doesn't reply within 60 days. But I'm sorry to say that this is on the part of the judiciary, and I have gone for as a contempt of court in the Honorable High Court of Punjab, and no action was taken. Actually, what I today want to say this thing, with your due respect to this house as well as to the Honorable Justice sitting over here, that this is 100%, this is the mistake, responsibility of judiciary, that they are not taking the hard decision against this administration, against this executive. And if the judiciary just become a bit strict against this administration, the whole scenario can change. No contempt of court petition is dealt properly, and no penalty is levied upon the erring officers. That's all.
Okay.
Thank you.
Yeah. You can just, whatever you have said, you can send to me by WhatsApp or like that. So in final compilation, we will take it up. Yes, sir. Now we go for discussion, concluding part. Again to Dr. D.L. Chawda ji.
In conclusion, friends, I want to say...
will be given by Professor Karya. You can just have the discussion part, whatever Dr. Rajkachuru wanted question first.
Yeah.
I
would have said, if I would have said that in today's meeting, Rahul Gandhi is going to join us, how many people would be there in our meeting? If I say that PM Narendra Modi is going to join, how many people would be there? Until, what I want to conclude, friends, is until we have masses with us, we won't be able to give an efficacious result. And there is a very, very famous, wordings from, I don't know whether it's from Galileo or Newton, that give me a lever and a place to stand and I will move the earth. Give me a fulcrum and move the world, something like that, right? We have a fulcrum, friends. We have a lever. In terms of digital marketing era, we have a digital tools available. I can assure you, friends, we can connect lakhs and millions of people together with our mission, because we are working for the masses. But the only problem is that we are working in isolation. Nobody knows us that for what we are working, correct? So until the people's sympathy is with us, probably technical things, technicalities and everything would not bring that much result. It should be a voice from the masses, because we are into democratic country. It is for the people, of the people, and by the people. And we have a tool by digital way. We can connect the people. I can assure you some of the tools and some of the things right now also digital marketing book is lying on my desk. We can connect lakhs and lakhs of people with us, right? And that only should be the solution. That only should be the conclusion from my end, friends. Okay, thank you.
Remember, you are muted.
I will say only one thing to Mr. Chawda, that all these efforts, whatever we have done till now, actually the problem is when the litigant is, we are asking them to raise the voice, they say, contempt of court ka dar lagta hai, sab hum kuch nahi kahenge. So use of social media can be the best way, what you have suggested, and we will work on that and we will discuss, and we will discuss about planning a next webinar exclusively on this subject.
As I said, no, sir, in UP election, approximately 100 vacancy, 100 seats are won by BJP by the margin of.
No, I know
200,
that.
300.
Everybody knows that.
So that is, yes, but that is a good way of connecting the people. That, we can generate the pressure groups.
Can I say
We will
something
discuss
here?
about social media. Yes,
Praveen
Raj
bhai,
Kachru,
can I
sir.
say something?
Yeah.
I wanted to tell Dr. Chawda that we have tried mass movement and did not have great success results to demonstrate, to show. The Forum for Fast Justice has been working for so many years, went from district to district, did yatras and so on and so forth, but we did not see major interest of public in this. For most public, this is some kind of a dull, distant area. Most people do not even want to go near court. They don't want to hear about it. But there is no harm in trying social media and so on to create a small amount of awareness and get some more people in it. But my question, what I was saying is that just now, Mr. Raghavan also said, my humble request to you is this. We must do ABC. And so everybody says we must do ABC, we must do ABC, but we are talking between ourselves. Unless we bring this ABC to the judiciary and to the government, it is of no value. We all are talking between ourselves. So we need to bring this matter to the government and to the judiciary, not only to judiciary, also to the government, because there is a Ministry of Justice which has got tremendous functions and tremendous role. They can do, and they pretend to do. We were just talking about this scheme where old people should get preferences, old cases should get preferences. They have a scheme for this. There is a scheme which is supposed to be that a person is supposed to be in the court informing the judge that these are old cases, this is pending for so long, bring it to their attention. But those people who are in those schemes have been appointed as sifarshis and they have nothing. They don't even know which cases are old and which are there, and they do nothing. They just come and sit there and do whatever. My point is, that is why I said, as a civil society, whether we are 20 or 200 or 300 or even 2,000, we need to engage with the government and judiciary. It is easier to engage with the judiciary because you have a provision of getting with the writ petition PIL and you raise an issue. Accountability of executive is an issue which can be raised. At least it will come into discussion. Many other things can be raised, like we raised from time to time many things. Mr. Bali was telling me that who stops me to file a PIL? I said, nobody stops me filing a PIL. I have already about 26 court cases at the moment in different courts in India. But as a small organization, I cannot handle 200. That is why I said, as a federation and as a group, we need a research team who can do proper research, because going into the court with one petition takes months of data, research, preparation, and so on. It's not easy for a small organization like mine to do.
Sorry to interrupt you, Mr. Kachru. When you are already the president, already holding the chief position since last 5 years, I am in Australia, but you are in India. You can do it. How we will do it? How, who will, what you call, bell a cat? Please bell the cat. We are with you. Do you need funds? Do you need our, what you call, support? We are with you.
Yes.
You should have to do it. You are the president. You must do it. We cannot wait it. I am coming to India. I told Mr. This one, Praveenji, that I am coming only for this in India. That I will come and I will not ask your assistance, your money. I will go to the court. And I will file my, what you call, the issues in the court, and I will file my petition in person. Why not you, sir? Why we are waiting for 5 years? Why not we are doing it? This is my question. Thank you very much.
Mr. Raj Kachru, can I just point out one more?
Yeah, please.
Mr. Rajkochu, for your information, whatever I have listed, 12 reforms, internal, both internal and external. I have circulated to the Prime Minister. I have sent a list to the Prime Minister, to the Law Minister of this country, to all Chief Justices of the High Courts in the country, listed out. Not a single one had even acknowledged. I leave it for action. But there are practical solutions I have suggested. Kindly, I will circulate this, go through them, and then comment on them. Thank you very much.
I will share with Raj Kachruji. After this webinar, immediately I will send to him.
Yeah, just one.
I will send to all the three. Shailesh Gandhi also, Justice Kachru also.
We are here talking about the principle. Principle is that when you have suggestions, you want to make changes, we need to engage with the government and judiciary. Judiciary, we can engage through PILs. Government, we have to push, because writing letters there is not going to do anything. We've been writing letters for the last 5 years. Nobody responds even for an appointment.
That is India.
No, whatever is India, but we
You
are
are
living
putting
in
a
India,
problem,
we have to
sir.
work in
You are
India.
putting up a problem. Give the solution. If they are not responding, what should we do? Do you want that we should immolate before their ministry? Or like,
you are right.
Tell us. This is the issue with our organization, that we tell the statistics, we tell the problems since last 5 years, and we are doing nothing.
Mr. Bali, can you kindly
that our associations are not, listen to me, sir.
Mr.
There
Bali.
are 120 units. They are all disheartened because nothing is being done by the headquarters. I tell you, everybody joined us for some cause. Everybody joined us for some results. We brought nothing more than the meetings in Delhi. That's all. I openly tell you, I put up this question mark before you, where you had handled it as a president. What for? What you have done till today?
Let him answer.
Only you are contacting the government offices and they are not replying you. You are putting up the presentation, nothing coming to you, and you are putting up this problem in the association, in the seminars. Is it our what you ये हमारी वीरता है क्या? क्या यही हमारी पोटेंसी है? क्या हम हिजड़े हैं कि हम कुछ नहीं कर सके 5 साल में? 120 सोसाइटी बनाकर बैठे हो इंडिया में. I'm really disappointed. हमारी जिंदगी खत्म होने वाली है. 18 साल का मैं होगा. प्रवीण जी आप भी जाने वाले हैं, मैं भी जाने वाला हूँ. जनरेशन को क्या देकर जाएंगे? क्या मुंह दिखाएंगे जनरेशन को हम?
इस प्रकार
हम आने वाली जनरेशन को क्या मुंह दिखाकर जाएंगे? क्या किया हमने 10 साल?
अंगुली उठाते हैं. हम अपने बात क्यों नहीं करते?
मैं करने आ रहा हूँ. मैं यहाँ बैठ के मैं तो अपनी सेक्रेटरी छोड़ के आ रहा हूँ.
Do it. Nobody stops you.
और मैंने किया भी. मैंने किया. मैं तो कह रहा हूँ मैंने तो किया भी. I brought so many changes in my state. मैं लाया अपने स्टेट में. तो आप यहाँ पर क्यों कहते हैं हम ये करेंगे, हम वो करेंगे? मेरे को जवाब नहीं मिलता, मैं जवाब नहीं देता, मैं गवर्नमेंट से जवाब नहीं आता. बस यही बात करनी है.
आपने बहुत बोल दिया, बात हो गया, आपकी बात खत्म.
प्रवीण जी,
कचरू जी आप बताइए आगे.
Let me answer him. आप खत्म हो गई.
ये तो डिस्कशन. दिस इज नॉट डिस्कशन.
अब इनकी बात
मैं कुछ नहीं करूंगा और आपको बोलूंगा आप सब करो.
भाई प्रवीण जी,
मैं क्या करूं बताइए मुझे. प्रवीण जी बताइए क्या करूं.
लेट हिम स्पीक.
बताइए चलिए.
डिस्कस अगेन. उसके लिए अलग से वेबिनार रखेंगे.
नहीं उसके लिए आप अकेले बात करेंगे. बट करिए ओपनली बात करिए. मेरे से क्या चाहते हैं आप?
सबके सामने करेंगे.
सभी के सामने बोलिए क्या चाहते हैं. आज क्वारी दीजिए क्या चाहते हैं.
शैलेश गांधी हैज टू लीव एट 7 o'clock.
This is an excuse. कोई ना कोई तो बहाना हमने बनाना ही है. डिस्कशन करिए, पॉजिटिव डिस्कशन करिए. क्या करना, मेरे से क्या चाहते हैं?
मैं बात कर सकता हूँ कि फिर मैं
बोलिए
छोड़ के चला जाऊंगा.
म्यूट कर दो फाइल मोल.
Let me answer this question.
Say something.
त्रिपाठी सर.
एक मिनट त्रिपाठी जी, मैं जरा बात करना चाहता हूँ. 2 मिनट.
माली जी जो है चीज को टाइम को खराब कर रहे हैं.
I need to answer this allegation or whatever.
क्योंकि गांधी साहब को 7 बजे
अगर मुझे बात करने देंगे तो मैं करूंगा, नहीं तो छोड़ दूं.
Please leave it. Please leave it. Please leave it.
भाई मुझे भी तो बात करनी है.
Leave it, sir. Leave it, sir. Kachru sir, no need to reply.
No, I need to reply to these things.
Just leave it.
Just listen to me.
त्रिपाठी सर आप बताइए.
आप सुनिए मेरी बात.
बात में सुनेंगे.
Federation का was worked on.
We are not here to give.
You don't. Praveen bhai, will you allow me to speak or I leave and go out?
अब फिर डिस्कशन करेंगे तो ये this is not.
आप मुझे अगर बात करने देंगे तो मैं करूंगा.
बोलिए.
Federation was built for access to justice. For this job, that is how I accepted to work for access to justice. Today, the amount of work our federation has done in access to justice is unparalleled in the last 75 years of India's history. Unparalleled. We have provided technology to NALSA to run their 15100. In 2 states, it operates. In 34 other places, it doesn't operate. We developed this technology, we paid for it, we are operating it. We have done 25,000 women's cases in the last 5 years, from domestic violence to sexual abuse to everything. 25,000 case files we have today in the computer on the cloud for minute-to-minute log of 25,000 case files. And we have developed technologies worth hundreds of crores to do. Today in Jammu, a woman can call, one woman calls any helpline, and within 7 days, we get her a protection order under PWDVA, custody order, children's custody, interim maintenance, and counseling order at her home. She doesn't leave, she doesn't go anywhere. This is what Federation has done. We have nearly 12, 15 PILs working in different places. That is why I said Federation does not have huge research team. I'm working alone with 2 or 3 of my researchers together.
Also talk about 15100.
Just one second. We need, that is why I said we need a research team to expand our work. We need to go more aggressive with the government. We don't need to get aggressive with the judiciary. We are quite doing very well with the judiciary. Judiciary does not have magical solutions to solve this problem. We need to produce the solutions and go, like in 15100, we said access to justice on a telephone. You don't have a solution, we have a solution, cooperate with us. It took 4 years to convince the government, to convince NALSA. But once it is working, and it is working. So Federation is not, it's not that we have done nothing for the last 5 years. We have done unparalleled work. As I said, I use this word in particular, unparalleled. We have launched a major campaign on domestic violence, and we have developed a solution that within 1 week, nobody in the world can beat that amount of that what we have done for the Federation. But there are hundreds of other issues. We can't take with hundreds of other issues. That is why I requested, that's why I was looking for Bhagwanji. We need a research team. We need a proper system to go into courts regularly, because only courts will give us the solution. Government is not going to give us the solution.
Okay, Kachkoji. Okay. I will just give an example. Baliji, आप सुनिएगा. छत्तीसगढ़ की बात करें. छत्तीसगढ़, since last 2 years, we are working with NALSA in Chhattisgarh 15100. Chhattisgarh ranking in World Justice Report 2020 and 2021. अब जाके it has jumped to 10 points. पहले जो था अभी वो दूसरे या तीसरे नंबर पे आ गया है. Number of cases that report which Dr. Raj Kachru has published, उसको भी आप पढ़ लेना. Then you could raise the question. त्रिपाठी साहब आप कुछ बोलेंगे?
Yes.
आप 2 मिनट शॉर्ट में बोलिए, फिर शैलेश गांधी जी बोल के निकलेंगे.
I have nothing much to say. I have said the problems are known to everybody, and solutions we have been discussing for last almost 12 years. Since our Bhagwanji Bhai have started the yatra, which you people have forgotten, for mass awareness. That is one of the events which our Mr. Gentleman from, I just forgot the name, Chawda, he had to see that the mass movement was started and the whole country was churned. And what Raj Kachru has explained, this is what I wanted to say. He has already explained, I have nothing to make. Everything needs people and money. Now, where is the people? Where are the people and where is the money? Raj Kachru is only asking for people. He is only saying, teaching research team. So we as an organization, what we are doing, we just not only talk about it, we have to also contribute to do it more and more. That is all I want.
Thank you, sir. मैं कैप्टन साहब के बारे में 2 शब्द बता देता हूँ. He is the man who is retired from the Indian Army. He has fought, जो 65 की भी लड़ाई लड़ी है, 71 की भी लड़ाई लड़ी है. 62 की मैं मालूम नहीं मुझे कि कैप्टन साहब आप ही बोल सकते हैं। 62
लड़ाई के
और
बारे में
नहीं,
लड़ाई
62
के
की
बारे
लड़ाई
में
आप
नहीं,
लड़े थे
मैं
कि नहीं?
सिर्फ ये कहूंगा कि एट द एज ऑफ 83 as Bhagwan ji bhai, even today, what I am saying, what he has started, we must strengthen that instead of talking what Bali and Raj Kachru has said. Probably there has to, we have to avoid all this. I have only said that our model, Dr. Mr. Chandru is the model, so that is to be studied and that should be presented to the government for conducting more cases per year. That will reduce the burden.
Thank you. Sailesh bhai, can you give us 3-4 minutes?
In 2 minutes, I'll finish. In 2 minutes, I'll finish.
No. Justice, sorry, Professor Karia will give concluding remarks. So before that, 2 minutes आप बोलिए, 3 minutes उनको सुन लीजिए, then we will wind up.
Okay.
Okay.
In my opinion, better judges, reforms, etc. are big names, and I see this. I've been hearing this in the last 25-30 years with no improvement, zero improvement. The only service in India that has deteriorated since independence steadily is the judicial delivery system. Everything else has improved, maybe very slowly, but there has been improvement. My submission is look at it and accept that these are the kind of judges we'll get. This is the kind of thing we'll get. And with that, our analysis shows that we don't need 3 times the number of judges, which is the civil societies and the Supreme Court's cry, which is completely irrelevant and absurd. And it will never happen. Whereas the truth is that a 20% increase in the actual number of judges will resolve the problem as far as our current case loads are concerned. And each year we would go down in backlog by about 10 to 15%. And in 6-7 years, we can see a solution to this. That's all. Thank you.
Okay. Chandruji, 1 minute. Anything to say?
Mr. Sailesh Gandhi asked me to write about my experience in disposing of matters. So I promised that I'll write something and give it to you for increasing the material on this issue. That's the only promise I can give you. It may take some few months. I will definitely document how this was possible. Even if you don't want to look into it, at least we can take it to the citizens of this country. This is how it
Mr. Raghavan has sent me some piece of paper that also I will share with you. Mr. Raghavan is from Chennai also. Ashwin Bhai Kariaji, concluding remarks.
Yes, thank you, Prime Minister. आज हमने जो स्पीकर्स को सुना, जैसे जस्टिस के चंद्रू जी, शैलेश गांधी, डॉक्टर राज कचरू, डॉक्टर चावड़ा और प्रवीण भाई भी, इससे हम ये कंक्लूजन पर आते हैं मेरे मतलब से कि जैसे जस्टिस चंद्रू जी ने बताया कि देयर इज नो सीरियसनेस ऑन द पार्ट ऑफ आइदर द गवर्नमेंट, आइदर ऑन द साइड ऑफ द जुडिशरी और इवन ऑन द साइड ऑफ द पार्लियामेंट. We like to agree with that statement, but at the same time, he raised the issue of accountability. You see, accept impeachment provision in the Constitution of India. You see, there is no specific reference with regard to the accountability of higher judiciary judges. Now, but I think that, of course, there is no express provision, nor there is any statutory body to regulate the conduct of the Supreme Court and High Court judges. But at the same time, I feel that as in the Constitution preamble, there is a specific provisions that we have decided to render economic, social and political justice to our citizens. And everybody, I mean every High Court judge and every Supreme Court judge, before taking over charge, he takes oath. He is under an obligation to take oath to protect the Constitution, the rule of law, and other statutory provisions. By that, he already, of course, indirectly becomes accountable to the public, because our Constitution is people-oriented Constitution. And therefore, judges are definitely accountable to the public, to the parliament, and to the government also. I have written a chapter in my book on the accountability of judges. This is in short. Now, with regard to appointment of judges in the higher judiciary, there is an uproar in the country because judges themselves cannot make judges. And there are serious allegations of corruption and favoritism. You see, Mr. Shanti Bhushan, our once upon a time, our law minister, has already given a sealed cover to the Supreme Court, making allegations against 8 judges of the Supreme Court of corruption. Still, till then, we have not, seen any reply or any progress in this case. About our Shailashji Gandhi, he was very much worried about the vacancies in our structure. Now, he is of the opinion if the vacancies are filled in time, then solution can be have within 2-3 years. All cases can be completed. He has given certain figures also. One thing he is very right, that when a judge retires, then his retirement date is already fixed in advance. Then why names, proposed names should not be sent to the government, and when a High Court judge or Supreme Court judge retires, the very next day a new judge should be appointed and he should take over a charge as a Supreme Court or High Court judge, as the case may be. Then he was of the opinion that state is responsible for this anarchism. So, with regard to Dr. Raj Kalchru, I would like to point out his one good suggestion, that there should be a research team. Last month only, we had a meeting in Ahmedabad with regard to opening a chapter of Society for Fast Justice in Ahmedabad. Sukhdev Patel, मीनाबेन जगताप, ये डॉक्टर DL चावड़ा, सभी लोग आए थे उसमें। तो उस वक्त हमारा ये भी सजेशन था कि हमें क्या होता है कि पूरे स्टेट में डिस्ट्रिक्ट वाइज हमें एक टीम भेजना चाहिए और डेटा कलेक्ट करना चाहिए, तो कैसे कैसे केसेस कौन सी कोर्ट में कितने लंबे समय से पेंडिंग है, तो उसके बारे में और उसमें क्या सॉल्यूशन हो सकता है। तो मेरे ख्याल से ये जो रिसर्च टीम का सजेशन है बहुत ही अच्छा है। और जो प्रबोध जी ने जो बात बताई कि राज कचरू जी को PIL करना चाहिए, राज कचरू जी ने उसके बारे में बहुत ही अच्छा रिप्लाई भी दिया, उसका हम नोट करते हैं। देन ये क्वेश्चनरी में ये भी बात अच्छी हुई कि भी गवर्नमेंट इज द मोस्ट पावरफुल लिटिगेंट इन कोर्ट्स, मतलब कि 50% केसेस ये गवर्नमेंट के एम्प्लॉयज के बारे में होते हैं। जहां तक मैं जानता और समझता हूं, मेरे ख्याल से क्या होता है कि गवर्नमेंट लिटिगेशन 2 प्रकार के होते हैं। वैसे उसके एम्प्लॉयज के बारे में होते हैं, जैसे करप्शन के बारे में होते हैं, डिसिप्लिनरी एक्शन के बारे में होते हैं, प्रोसिक्यूशन के सैंक्शन के बारे में हो सकते हैं, ग्रेच्युटी, पेंशन सभी के बारे में हो सकते हैं। और प्राइवेट सिटीजन्स को भी ग्रीवेंसेस होता है गवर्नमेंट के अगेंस्ट गवर्नमेंट। तो ये सब बातें क्या होती है कि जैसे ये कनु भाई ने अच्छा पॉइंट उठाया कि अगर आफ्टर सर्विंग नोटिस अंडर सेक्शन 80 ऑफ CPC, if the government does not reply and the citizen is compelled to seek the relief from the court, then why not the government bureaucrat should not be held liable? ये अच्छा सजेशन है। मेरे ख्याल से ये रूटीन हो गया है कि गवर्नमेंट को कितनी भी नोटिस कोई भी भेजता है तो उसके ओर से कोई रिप्लाई नहीं आता, कोई रिलीफ की बात नहीं होता। मेरे ख्याल से अगर गवर्नमेंट की ओर से रिप्लाई होता तो क्या होता है कि देयर इज सेटलमेंट ऑफ इश्यूज इन डिस्प्यूट, कि गवर्नमेंट और सिटीजन या एम्प्लॉय हुएवर में भी उसके बीच में डिस्प्यूट क्या होता है उसका एक सेटलमेंट हो सकता है। तो क्या होता है कि इस सेटलमेंट के बारे में मेरे ख्याल से प्री लिटिगेशन मीडिएशन होता है तो कई केसेस कम भी हो सकता है, क्योंकि गवर्नमेंट जहां तक क्वेश्चन है तो गवर्नमेंट तो उसको लीगल डिपार्टमेंट को ऑर्डर देता है कि भाई अपील फाइल कर दो। लेकिन जो सिटीजन है, एम्प्लॉय है, मैं जानता हूं कि पेंशन के केस में हमारे जो फ्रेंड्स है 15 लोगों ने, प्रोफेसर्स थे, उन्होंने गवर्नमेंट का ऑर्डर मिला, गुजरात हाईकोर्ट का ऑर्डर मिला कि 3 मंथ में उस सबको पेंशन देना चाहिए। government delayed in filing appeal. It went on seeking time and time. Then the सुप्रीम कोर्ट में अपील फाइल की, फिर कोरोना आ गया। 5 साल के बाद सुप्रीम कोर्ट ने भी यही ऑर्डर दिया कि उन सबको पेंशन मिलने चाहिए। लेकिन बीच में हमारे 2 फ्रेंड्स तो गुजर गए थे, तो इसका क्या मतलब? तो गवर्नमेंट का भी कुछ अकाउंटेबिलिटी होनी चाहिए कि सभी केसेस में अपील फाइल करने का नहीं होता है, और जो उसके लिए जिम्मेदार अधिकारी होता है या कोई वकील होता है उसकी भी जिम्मेदारी होनी चाहिए, ये हम समझते हैं। तो ये डिस्कशन भी अच्छा हुआ। तो मेरे अभी रिसर्च टीम का जो आइडिया है तो मुझे अच्छा लगता है, उसके बारे में एक वेबिनार भी हो सकता है। तो हम अहमदाबाद में भी यही सोचते हैं। तो ये मेरा कंक्लूजन है, टाइम भी बहुत हो गया है। तो प्रवीण भाई मुझे मौका
बहुत धन्यवाद कारिया साहब।
धन्यवाद आपका।
या we will
सब
discuss
लोग
about
जो सुना है उसका भी मैं नमस्कार करता हूँ। जय हिंद।
नमस्कार। आपने जो कहा उसको ध्यान रखते हैं और कचरू जी के साथ और आपके साथ भी बात करके एक वेबिनार एक्सक्लूसिवली ऑन दिस सब्जेक्ट हम लोग आपस का इंटरनल करने के लिए प्रोग्राम करते हैं, जिसमें गुजरात चैप्टर भी साथ में आ जाए और दूसरी सोसाइटियों को भी हम लोग इन्वॉल्व करेंगे। तो अभी टू एंड अप दिस थिंग आई रिक्वेस्ट बुद्धार्थ सोसाइटी, हरेंद्र जी आप हैं क्या? हरेंद्र जी, बुद्धार्थ सोसाइटी फॉर फास्ट जस्टिस, अनम्यूट कीजिए।
मैं हूं सर।
हाँ, वोट ऑफ थैंक्स दे दीजिए।
मैं हूं सर।
या वोट ऑफ थैंक्स के लिए आपको बोल रहे हैं।
हेलो।
हाँ, वीडियो ऑन कीजिए। धन्यवाद। प्रस्ताव।
आवाज नहीं आ रही सर।
आपकी आवाज सुन रहे हैं। वोट ऑफ थैंक्स आप दे दीजिए, फिर वेबिनार को कंप्लीट बंद करेंगे। मुख्तार भाई आप ही दे दीजिए।
आप सभी को जो इतना बेहतरीन कार्यक्रम किए, इस सब के लिए आप सबों को, जो पैनलिस्ट थे और तमाम जितने भी लोग यहाँ से लोग थे, जितने लोग थे, सबको मैं तहे दिल से धन्यवाद ज्ञापित करता हूँ और सबको कह रहा हूँ कि इसे दोबारा रिपीट किया जाए। धन्यवाद सर।
Okay. Namaskar. So we end this program with conveying a lot of thanks to you, Justice Kachru ji, Chandru ji, कासिया साहब, चौड़ा साहब और कचरू जी शायद है कि नहीं पता नहीं, and all our friends who are here, and we will share the details etc. YouTube link also we will share with those who are interested. Or regarding future course of program, we will discuss among ourselves about the study team, research team, etc., and how the social media program can be taken up by Gujarat chapter also, and how what we can do together with them. All these issues will be discussed internally and then come up with a webinar. Thank you, sir, and goodbye to everybody.